This is an application with Duduzile Zuma-Sambudla to be released or remitted on bail pending her trial, which I just been informed will take place in Durban High Court. For purposes of expediency, I will not repeat or reread all the entire content of the articles of affidavits, but I will just refer to those aspects I consider pertinent for exercising my discretion insofar as it relates to bail. The applicant was arrested this morning, and in terms of arrangements made with the defense, was brought to court. And it is common cause that this is an application for bail to be dealt with under Section 6011A of the Criminal Procedure Act of 1977. The parties are highly therefore of like mind in that regard. I am also satisfied, having regard to the charges as they have been framed in the charge sheet, particularly in respect of count 1, relating to the protection of constitutional democracy against terrorism and related activities, Act of 2004, referred to as, or I will refer to in short as FOCCARA. That the offences do indeed fall under the ambit of what we commonly refer to as Schedule 6. In terms of Section 6011A, an accused person faced with an offence which falls within the ambit of Schedule 6, the law provides that such person shall be kept in custody until given a reasonable opportunity to adduce evidence to satisfy the court that exceptional circumstances do indeed exist, which in the interest of justice, permits the release of the applicant on bail. Since the amendment to the bail legislation in 1998, there are literally hundreds, if not thousands of cases dealing with the issue of Schedule 5 and Schedule 6 bail application. When the Section 6011A and B was promulgated, it was done so by Parliament in order to control serious and violent crime. And its intention was never to deny a person charged with a Schedule 5 or 6 offence the opportunity to be released on bail. Rather, it made the bail provisions less liberty-orientated rather than totally. So it is not impossible. Mr. Impofu has submitted that the usual circumstances that one meets in every bail application are indeed, or could indeed be exceptional. When I consider the issue of exceptional circumstances, in addition to the various cases by the Constitutional Court, State versus Shamin and the other cases in 1999, the cases by the Supreme Court of Appeal and the various divisions of the High Court. What is clear is that it should be something out of the ordinary, and ordinary circumstances will be sufficient, but if there are a whole host of circumstances considered cumulatively, there may be circumstances which individually may meet that requirement. But in this case, I'm also struck by the state, who have no objection to your piece on bail. They have placed on record as they obliged the reasons therefore. All your favorable circumstances, coupled with the attitude of the state in not objecting to your release on bail, I am satisfied it crosses the threshold of proof that there are indeed exceptional circumstances which are present. The reason why I inquired on both counsel regarding the arrest as a manner of securing your attendance at court was in view of the whole host of favorable circumstances, even submitted by the state itself. There is nothing in the affidavit of the investigating officer to even remotely suggest that there would be any risk in releasing you on bail. There has been no conditions that have been submitted, and I don't think I could, but I don't think in this case there are any reasons or basis for me to impose any conditions on you with your release on bail. There is exceptional circumstances which I considered in terms of Section 16, I think it is subsection 4 of the Criminal Code. It must meet the requirement of the interest of justice, and the interest of justice is a value judgment that the court takes into account, taking into account various factors enumerated by the legislature. So the legislature has gone to the extent of prescribing what is not in the interest of justice. For example, if you were to interfere, there's a likelihood that you interfere with state purposes with investigation. But the total absence of any such factors or circumstances which have been placed before me. So I accept that your whole host of favorable circumstances, coupled with the attitude of the state and whatever you disclose in your affidavit, those exceptional circumstances do, in the interest of justice, permit your release on bail. I am also obliged in terms of Section 16, subsection 9, to take into account a whole host of circumstances and factors. For example, the need for you to consult with your legal representative. When is it likely that the matter will indeed proceed to trial, if it does indeed proceed to trial? These are all factors which the legislature has enumerated that the court must take into account. So considering the matter holistically, I am satisfied then that those exceptional circumstances do in the interest of justice to the care of these one day. Regarding the just on those factors, if I may just mention that the bail legislation, one is it's not geared towards making factual conclusions, but when they amended the bail legislation in 1998, it was designed for the courts to make an informed prognosis of what is likely to happen and not happen. And in view of all the circumstances placed before me, I can see nothing negative in GDCU on bail. The amount of 3,000 there was suggested. I think, although not directly implicit in the submissions by the state, is that perhaps it has some degree of symbolism attached to it. I don't think the court should be in the business of making orders which are symbolic. We should be dealing with the matter as the facts appear before us, and having invited parties to make a submission beyond. I therefore decline to fix an amount of bail. In terms of Section 72 of the Criminal Procedure Act, I think all the circumstances in this case point to you to release on warning. In terms of Section 72 of the Act.
As the court pleases, Your Worship. Your Worship, I have an indictment which needs to be served upon the accused. The date for transfer to the High Court is 20th March 2025.
Yeah.
Have you said that when you do that
Thank you, Your Worship. Your Worship, it's the other one that goes. Ask. Can you please serve it on the assist?
So, for the purposes of record the indictment, which include the summary of the substantial facts consisting of 5 paragraphs and the list of witnesses, is marked Exhibit C.
As copies, Your Honor.
Confirm, Ms. Zuma-Sambudla, do you confirm that you received the indictment?
Yes.
Okay, and it contained the summary of substantial facts and the list of purposes. Thank you very much. I confirm that it has been duly served. And don't we have a notice of trial when we served?
The notice of trial is attached to the copy that was given to the accused.
Oh, it's not on this copy?
Not on that.
So, Ms. Zuma-Sambudla, the matter is transferred to the Durban High Court, which is currently just housed in the opposite end of Mr. Wood. I see there's no court specified, but I'm sure Mr. Pope will assist in that regard. For the 20th of March this year, at 8:30, the matter is being postponed as a provisional date. So, depending on what happens, and the matter will then be adjourned either for a pre-trial and then a trial, but depending what happens. But please report to the court at the Durban High Court on the 20th of March this year at 8:30. Should you fail to appear, your arrest will be authorized and you can be kept in custody pending finalization of this matter. Do you understand, Ms. Zuma-Sambudla? Do you understand? Thank you very much.
Your Worship, I'm afraid there is.
Yes.
Just a small matter. The Worship, yes, we've just now been served with the indictment.
Yes.
And I know that the decision on bail has been made, Your Worship. But since this is a matter of public interest, I would like to remark on the fact that this so-called terrorism charge, Your Worship, seems to be out of sync with what my learned friend says was the complaint. According to him, the complaint was as incitement to public violence and the incitement to malicious injury to property. So, it's just to say, Your Worship, once again, at the appropriate forum, it's the issue of malice will be dealt with, because it's not clear now where the terrorism came from. Seems to be just a need to create drama and to elevate this to a Schedule 6 offense artificially. And I'm not, again, accusing my learned friend personally, but as a matter of concern, it has to be said that this whole business smells with something fishy.
I think there's issues with the game here. You intend to bring representation to the National Director.
Yes.
Although it has been authorized by the National Director, we obviously know that when representations are made, it includes representations by the accused, as opposed to this constituting the state's case. So that's always at your disposal, but it can be sorted out in legal.
With respect to Your Worship, I think I have the right to reply to a certain submission by my colleague that these things were escalated. Your Worship, sometimes a complainant may make a charge and say, somebody has come to my house and done a certain thing. Further investigation revealed that he had a firearm in his possession. It doesn't mean we can't charge him for the firearm. The complainant said one thing. The investigation revealed that it was an act of terrorism, and that is why there's a charge there. I think we mustn't now try, because the media is present, to play games.
But I think what I've suggested would be the idea. You made those representations.
Yes,
thank you very much. All right, thank you, Ms. Zuma-Sambudla. 20th of March, Durban High Court, Copper State, Division Point. I'm yet for all of you and the court.
When the judge comes.